My name is Susan Feeney. I'm the president of the State Bar Foundation, and the State Bar Foundation is the entity that conducts the mock trial. And it's my pleasure to welcome you to the final championship round of the 2018-2019 Vincent J. APRUZZESE mock trial competition for high school students, sponsored by the State Bar Foundation. This morning, Colts Neck High School of Monmouth County and Mainland Regional High School of Atlantic County will vie for the statewide championship. At the end of today's trial, one of these teams will emerge as the first place winner and the other will achieve second place. Today's victor will represent New Jersey in the National High School Mock Trial Championship to be held in Georgia. We are now ready to begin the final round of our 37th mock trial season. Have fun today and learn as you begin your careers as litigators. Good luck to all. Thank you.
We are here this morning for the trial of Avery Mansion versus Captain Kids Pier. Are there any preliminary matters, counsel? Welcome, counsel. Good morning.
A mock trial is a great learning experience. I think it's important because it allows the students to learn a little bit about our democratic process and how law functions, and to me that's the bedrock of our democracy.
To our jurors, we're going to begin with opening statements. That is not evidence. The evidence comes from the testimony you're going to hear and from the exhibits or stipulations that are presented. Opening statements are argument, a way for you to understand the evidence that will be presented. Who will be opening for plaintiff?
I will, Your Honor.
You may proceed.
Thank you. May it please the court. This was an accident waiting to happen. On Saturday, August 19, 2017, recent high school graduate Avery Mansion arrived at Captain Kids Pier, an amusement park, with her best friend, looking forward to some fun in the sun at the shore. Just a few weeks later, Avery would be off to Rutgers University on an arts scholarship. So on that day in August, the two played some carnival games before deciding to ride the Hurricane, a roller coaster at the amusement park. What was supposed to be a fun day in the sun turned out to be a dark day that changed the course of Avery Mansion's life. Miss Mansion left Captain Kids Pier that day with life-altering injuries. Gone was her ability to hold simple objects in her hands. Gone was her ability to paint and draw. Gone was her scholarship, and gone were her dreams for the future. What happened to Miss Mansion that day could have happened to anyone who walked through the gates of Captain Kids Pier. Ladies and gentlemen, today you'll learn that what Avery Mansion walked into was not an amusement park, but a circus. Nothing amusing about that. The pier was overrun by rowdy teenagers looking to make trouble. The ride operators were half-blind buccaneers. The warning signs were obscured from sight. The rides were in urgent need of repair. The park's mechanic knew that. The park's owner knew that too, but they chose to ignore these facts. And so on Saturday, August 19, 2017, when Avery Mansion arrived at this circus-like atmosphere, the gates to Captain Kids Pier were still open for business. The fact is, ladies and gentlemen of the jury, at the end of today's trial, the evidence will show that Captain Kids Pier acted negligently in allowing this park to remain open and operating for the public. This was an accident waiting to happen, an accident that did happen to Avery Mansion. For that reason, at the end of today's trial, we will ask that you find the defendant, Captain Kids Pier, liable for the injuries suffered by Avery Mansion. Thank you.
Thank you, counsel. Who will be opening for the defense?
May it please the court, your honors, opposing counsel, ladies and gentlemen of the jury. We've all heard the expression, actions speak louder than words. You just got done hearing the plaintiff's words. Along with their name calling, they claim that a ride on the Hurricane roller coaster caused severe, intense, painful injuries that forever changed the life of Avery Mansion. Mock trial just improves my people skills. I've learned how to communicate with people, to argue with people in a more civil way, and to learn how to public speak, which I think is such an important skill. I've also learned how to be a leader. I'm the captain of my mock trial team, and I've made so many friendships. It's just helped me in so many different areas. But the plaintiff's actions after riding the Hurricane roller coaster will tell a different story. Today, it is the plaintiff's burden to prove that Captain Kids Pier was negligent, and that this negligence was the proximate cause of the plaintiff's injuries. They will not meet that burden. Lynn Pingree, the owner of Captain Kids Pier, will tell you that the Hurricane roller coaster is equipped with safety devices specifically for the passenger's head and neck. Today, the plaintiff's own words will tell you loud and clear that she was not injured at Captain Kidd's Pier, that Captain Kidd's Pier was not negligent. So at the end of this trial, my co-counsel, Georgia Ridgway, will ask that your words reflect what the plaintiff's actions show. Captain Kidd's Pier is not liable. Thank you.
Plaintiff, please call your first witness.
Plaintiff calls Avery Mansion to the stand, Your Honor.
Will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the court.
Avery Mansion.
Thank you.
Good morning, Ms. Mansion.
Good morning.
Could you please state your name for the record?
My name is Avery Mansion.
And how old are you, Avery?
I'm 20 years old.
Are you in school?
Yes, I attend Metropolitan Community College.
Was Metropolitan your first choice?
No, I was actually planning to go to Rutgers prior to the accident. I had a full scholarship.
What were you planning to study at Rutgers?
I was going to study art. I got into a top 10 program for painting and drawing.
Why did you want to become an artist?
Well, ever since I was young, art has always been my passion, especially oil and watercolor. It's the one thing I knew I wanted to make a future out of.
So, why did you lose your scholarship?
About a month after the accident, my hands would randomly go completely numb at times. It was to the point where I couldn't even pick up a paintbrush. I couldn't create art, so Rutgers took away my scholarship.
Well, Ms. Mansion, I'd like to talk a little bit more about that accident you mentioned. Let's go back to Saturday, August 19th, 2017. Where were you that day?
I was at Metropolitan Beach with my best friend, Aiden Lovecraft.
When did you arrive?
Around 10 a.m.,
And what did you do when you arrived?
we went to Captain Kidd's Pier.
What's that?
It's an amusement park along the beach.
So what did you do at Captain Kidd's Pier?
Well, we played some games, we played skee ball, and then we went on a roller coaster.
And what was the name of that roller coaster?
It's called the Hurricane.
You mentioned you didn't see any signs telling you to wear a seatbelt. Did you see any signs about the Hurricane roller coaster?
All I remember seeing were these obnoxious wanted posters of a pirate plastered across every flat surface around the park.
Did you seek any further medical attention after that day at the park?
Yes, the following day I still felt like I was in bad shape, so I went to an urgent care center.
And what did the doctors at the urgent care tell you?
Objection, Your Honor. This is hearsay pursuant to Rule 801 and inadmissible pursuant to Rule 802. The doctor at this quick care clinic or urgent care is not testifying in court today, and therefore it is hearsay.
Your Honor, this is not hearsay, as we are not offering this as the truth of the matter being asserted. In fact, we are disputing what the doctors at the urgent care told her. We are only bringing this up so we could discuss how the witness responded and why she didn't immediately seek treatment after going to the urgent care center, and that was because of what the doctors told her, which is not what we are asserting in this case.
Allow the answer to begin, and we may not permit you to provide a fulsome answer. So let's hear what you have to say, please.
What do the doctors at the urgent care center tell you?
They told me that nothing was wrong with me. They said I was completely fine.
Did you get a second opinion on that?
I did. The following week I still felt bad, so I got an appointment with my doctor and I got an MRI.
And what did the results of that MRI show?
It showed that I had 2 herniated discs.
Objection, Your Honor. This is an improper opinion pursuant to Rule 701 and inadmissible pursuant to Rule 702. While Avery Mansion can testify to her symptoms and how she feels with this injury, she cannot testify to the actual diagnosis, as she is not an expert in today's case. Furthermore, this would be hearsay for her to testify, as the doctor she got this opinion from is not testifying in here today.
Your Honor, we're not having the witness conclude anything. We're simply asking her to describe her medical history. What is more, we're not offering this as the truth of the matter being asserted. In fact, we will be calling a doctor later on in the trial to do just that and describe the records that she used to make her opinions.
Objection sustained. The witness can testify about what she did and how she responded to the diagnosis, but it's beyond her scope of knowledge to provide that medical link.
Thank you. How did you follow up to this appointment with Dr. Paulson?
I was pretty disheartened because I learned that my condition was pretty much permanent.
What has your life been like after this injury?
I can't do many of the things that I used to love doing. I can't create art. I lost my scholarship. I lost the one thing that I love most in this world.
Thank you. No further questions, Your Honors.
Cross-examination.
Good morning, Ms. Manchin.
Good morning.
Now, I'd like to talk to you about what happened at Captain Kidd's Pier. Now, the injuries you have, they're in the upper part of your body, in your neck, right?
Yes, they are.
Now, you'll admit that on the Hurricane roller coaster, there's a harness that comes down over the upper part of your body, right?
Well, yes, the harness sort of hovered over my shoulders.
And you'll also admit that there was a cushioned headrest behind your head on the back of the seat, right?
Yes, there was a hard headrest behind my head.
Hard, but nonetheless, it was a cushioned headrest, right, Ms. Manchin?
Yes, a hard cushioned headrest.
Now, before you could get on the ride, you saw the previous passengers get off the ride, correct?
Yes, I did.
And now, Ms. Manchin, I just want to be clear. You didn't hear any of those passengers getting off the ride make any complaint whatsoever about the ride, did you?
Well, I wasn't really paying that close attention to the people exiting the ride, so not necessarily.
Right, so since you weren't paying attention, you didn't hear anyone complain about the ride, did you?
No, not the people who came off after, no.
And when describing your experience on the hurricane, you made no mention of any stress or strain to your neck whatsoever during the ride on the hurricane, didn't you?
Well, I was experiencing a lot of stress in my neck during the hurricane, yes.
Ms. Manchin, that wasn't my question. You never mentioned any stress or strain to your neck during your ride on the hurricane, isn't that right?
No, I wasn't talking during my ride on the hurricane, so that would be no.
In your direct examination and during your statement, you never mentioned stress to your neck, isn't that true, while you were on the ride?
Yes, that is correct. I only mentioned it after I got off the ride.
Thank you. Now, let's discuss your actions after getting off the hurricane roller coaster. Now, after the ride, you claim that you felt terrible, right?
Yes, I was in a lot of pain.
But you didn't seek out the ride attendant or park employee to complain that you were hurt on their ride, did you?
No, the ride attendant wasn't there when I got off the roller coaster.
But you didn't specifically look for a ride attendant or a park employee to let them know, did you?
Well, no, I didn't see them, so no.
Thank you. And you didn't leave the park to seek help from a doctor or an emergency room, did you?
No, at the time I wasn't really aware of the severity of my pain, so I thought that I could walk it off for a few hours. So I did go do other stuff.
Just to be clear for the members of the jury, you didn't leave the park to go to a doctor or a hospital, did you?
No, I didn't go to a doctor or hospital that day.
And the day after you visited Captain Kidd's Pier, you didn't go to Dr. Paulson, the doctor you had been seeing prior to visiting Captain Kidd's Pier, to tell him that you hurt your neck, did you?
No, I didn't. He wasn't available that day, so I went to an urgent care center.
And it wasn't until a week after you visited Captain Kidd's Pier that you got an MRI from your doctor, Dr. Paulson. Isn't that true?
Yes, that is correct.
Now, let's talk about the damages that you claim you suffered. Now, you claim that you lost an art scholarship to Rutgers University because you were unable to paint and draw due to the numbness in your hands, correct?
Yes, that is correct. I can't paint or draw anymore, so Rutgers took away my scholarship.
Now, isn't it true that the numbness in your hands didn't begin until more than a month after you visited Captain Kidd's Pier?
Yes, it was about a month after that I started to develop numbness.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Ms. Manchin, that day, August 19th, 2017, why didn't you immediately leave the amusement park after you rode the hurricane?
After I got off the hurricane, I was in pain, but I felt like maybe I could walk it off, and I didn't want to ruin Aiden's day, so I decided to see how I felt after staying there for a while.
Thank you. No further questions.
Thank you. You may step down.
Plaintiff calls Aiden Lovecraft to the stand. Good morning, Ms. Lovecraft.
Good morning.
How old are you?
I'm 21.
And where do you live?
I live in Metropolitan.
How long have you lived in Metropolitan?
Well, I moved there my sophomore year of high school. I was an Army brat, but thankfully, Metropolitan was our last stop.
Do you know the plaintiff, Avery Manchin?
Of course I do. Avery's my best friend.
Ms. Lovecraft, I'd like to talk a little bit about August 19th, 2017. Where were you that day?
Well, I was with Avery. That was the day we went to Captain Kidd's Pier.
And why did you go to Captain Kidd's Pier?
Well, at the time, I found out that Avery had never been on an adult roller coaster, and I took it upon myself to fix that.
Did anything happen while you were online?
Well, as I said, the wait was pretty short, but as we were walking up to the ride and the last group got off, one man got off yelling.
What was he yelling?
He was yelling that
Objection,
the
Your
ride...
Honor. This is hearsay pursuant to Rule 801 and inadmissible pursuant to Rule 802. The man that they claim made this statement is an unknown bystander in today's case, and his claims we proffer go directly to the claims of negligence and the condition of the roller coaster. As we do not have the ability to cross-examine this man, as he is not testifying in court today, it is hearsay.
Your Honor, under Rule 803, Exceptions 1, 2, and 3, this is not hearsay. Under Exception 1, this is a present sense impression. The declarant, in this case the man, is describing his pain as he is feeling it. Under Exception 2, this is an excited utterance. The man is within mere seconds of getting off of this roller coaster, and he is still under an excited, agitated state. And under Rule 803, Exception 3, this is state of mind exceptions. Pain is a state of mind, and there would be no way to know that he was experiencing pain unless he declared it out loud.
Objections overruled.
Were you both properly strapped into the ride?
Well, I put my seatbelt on. I rode it before, so I knew that I had to. But when we got off the ride and Avery started complaining of pain, I suggested maybe her seatbelt hadn't been on tight enough. And that's when Avery asked me what belt.
Now, Ms. Lovecraft, I'd like to talk a little bit more about your experiences on the roller coaster itself. Had you ever ridden the Hurricane prior to that day in August with Avery?
Objection, Your Honor. This is irrelevant pursuant to Rule 401 and inadmissible pursuant to Rule 402. Today's case deals with Avery Mansion, and Aiden Lovecraft's experience on the hurricane is irrelevant.
Your Honor, under Rule 701, this witness is allowed to offer a lay opinion on her experiences that day.
While this case does deal with the hurricane roller coaster, I proffer that no expert will be called upon today to comment on the conditions and the safety of the roller coaster. Aiden Lovecraft is a layperson in today's case, and while she can testify to how the ride felt, any attempt to connect that to the actual conditions and safety of the hurricane is purely speculative and at best substantially more prejudicial than probative.
So the question right now is, have you ridden it before? You may answer that question. We'll see how much further down this line one can proceed. Go ahead. Please answer the question.
Have you ever ridden the Hurricane prior to that day in August with Avery?
Yes, I had many times, but that day was the first time that season.
And when you were riding, how did the Hurricane feel to you compared to your prior experiences?
As soon as the ride started, I sensed that it felt different, kind of loose.
Could you describe your own personal observations of her since that day?
Well, Avery's changed. She's kind of like a different person now.
How is she different?
Well, she seems depressed. Anytime I ask her if she wants to do something, she says no because her arms are acting up.
What happened to her arm?
Well, her right hand is pretty much just useless now. I mean, she can't even hold a paintbrush with it. And she tries, she really does, but she just can't. And watching Avery, it's clear to me that she's having trouble grabbing things with both of her hands.
Cross?
Now, when the plaintiff finally did come up, you heard her yell something about the bottom. Isn't that true?
Yeah, she was like bragging.
Miss Lovecraft, you didn't put that she was bragging in your statement, did you?
My apologies. She came up and yelled bottom, which was just kind of like a victorious, so bottom.
Now, when the plaintiff finally did come up, you saw her put her hand to her neck. Isn't that true?
Yeah, she like briefly touched her neck. I think she was getting a piece of seaweed or something like that.
Ms. Lovecraft, I'm not asking you to speculate as to what the plaintiff was doing with her hand on her neck. She simply put her hand to her neck. Isn't that true?
Yes, Avery briefly touched her neck.
Now, I'd like to talk to you about when the plaintiff decided to go on the hurricane. It was after the plaintiff dove into the bay, and after she came up, touching her neck.
Objection, Your Honor. This is a compound question.
Your Honor, the witnesses
You can break it up.
Okay.
Thank you.
Now, it was after the plaintiff dove into the bay that she decided to go on the hurricane, correct?
Yes, that is correct.
And it was after she came up, touching her neck, that she decided to go on the hurricane. Isn't that true?
Yes, that was our plan for the day.
Thank you. No further questions.
Thank you. Call your next witness.
Plaintiff calls Dr. Dharma Pavlik to the stand. Good morning, doctor. Please state your name for the jury.
Dr. Dharma Pavlik.
Doctor, what do you do for a living?
I'm an orthopedic surgeon.
How long have you been an orthopedic surgeon?
Since 1997.
With mock trial, what you really have to do is make sure that the logic is tight, and I find that to be a fun intellectual challenge. Because of mock trial, I see myself becoming a much clearer thinker, a much better public speaker. I speak my opinions with much more confidence, and I also reflect more before I speak what my opinions are, before I make statements of fact or assert my view on something.
When was that physical examination?
January 10th, 2018.
What were your findings?
Avery had difficulty gripping and grasping with both of her hands, although right worse than left. She also had decreased sensitivity to 4 of her fingers, and she lacked the full range of motion that she should have when moving her neck around.
So did she feel any corresponding pain in the neck?
Yes, she had bilateral paracervical muscle tenderness, and so what this means is when I touched her neck, she experienced pain on both sides of her neck, right and left.
If I showed you copies of the MRIs that you reviewed, would you recognize them?
Yes, I would.
Your Honor, permission to approach the witness with J2.
Your Honor, I must object to hearsay again. The witness did not actually view the actual EMG, just the report of the EMG. Therefore, this is hearsay as it is the opinion of the doctor, not testified.
Your Honor, these are the results of a medical study, and they've been relied upon by this expert witness in the formation of expert testimony, so they're not hearsay.
I'll allow the expert to testify with regard to it.
Doctor, do you state your conclusions today within a reasonable degree of medical certainty?
Yes, I do.
Thank you, Doctor. No further questions, Your Honor.
Cross-examination.
Good morning, Dr. Cobb. Now, you just stated your opinion that the hurricane roller coaster was the source of the plaintiff's injuries, correct?
Yes, her pain was consistent with what she described to me to be her experience on the roller coaster.
But you've never actually seen the hurricane roller coaster, correct?
No, I have not.
And you didn't see Avery Mansion riding the hurricane roller coaster,
No,
right?
I didn't.
Now, I'd like to talk to you about your evaluation of the plaintiff's condition. Now, you claim that the plaintiff has 2 herniated discs, correct?
Yes, she has 2 herniated discs in her neck.
And that means that the fluid inside the disc has been forced out of the disc, right?
Yes, this is the definition of a herniation.
Now, you'll agree that an MRI film of the spine would picture these discs, correct?
Yes, it certainly would.
So you'll admit that before ever riding the hurricane roller coaster at Captain Kidd's Pier, Avery Mansion was going to an orthopedic facility.
Yes, actually, the MRI reports does say that she had mild degenerative changes in her spine. However, this injury is not related to the herniations that were found afterwards.
I didn't ask you anything about relationships between conditions. I simply asked you whether or not Avery Mansion was going to a orthopedic clinic before ever visiting Captain Kidd's Pier. Yes or no?
Yes, she did.
No further questions.
Is defense ready to proceed?
Yes, Your Honor.
Okay, call your first witness.
Good morning. Could you please introduce yourself to the members of the jury?
Hi, I'm Lynn Pingree.
Ms. Pingree, could you tell the members of the jury what you do for a living?
Well, for the last few years, I've been a bit of an entrepreneur, but back in 2016, I purchased Captain Kidd's Pier, and I've been the owner and manager ever since.
Why did you purchase Captain Kidd's Pier back in 2016?
Well, first and foremost, it gave me a lot of flexibility in my schedule to spend time with my kids.
Now, Ms. Pingree, as owner of Captain Kidd's Pier, are you familiar with the hurricane roller coaster that we've heard so much about today?
Absolutely. The hurricane is and always has been the crown jewel of Captain Kidd's Pier.
Now, Ms. Pingree, are there any safety devices on the ride to protect the passengers?
Absolutely. We have plenty of protection for the passengers on the ride.
Thank you. No further questions, Your Honor.
Cross?
Yes, sir. Now, Ms. Pingree, I'd like to just take a minute to discuss this video that you mentioned on direct examination. This video you watched, only one copy was made, right?
Yeah, that's correct.
And this video showed the ride in its entirety, right?
Yeah, in its entirety.
Counsel and I didn't get to review the video, did we?
No.
This jury could not review the video, could they?
Objection, Your Honor. This is speculation. Lynn Pingree would not have knowledge as to whether these people have gotten to view the video, as it was lost before anyone got to see it.
Your Honor, I'm trying to establish that because this video was lost, that could clearly show the events in question, and as a result of it being lost, it's not available for us today in court, a video that's at the heart of this issue today.
Okay, I'm going to overrule the objection. I don't think there's a dispute that none of the people here viewed it, and you're cross-examining because you're challenging what she says she saw in the video, so overruled. Go ahead.
You were made aware of some issues with the hurricane roller coaster, weren't you?
Yeah, a few days after I heard the claim that there were some issues.
And specifically, you were made aware of some safety issues with the hurricane, right?
I wasn't made aware of any safety issues. I was made aware that somebody claimed they got hurt.
Well, Ms. Pinker, you were made aware that there was frayed padding on the U-frame harnesses of this coaster. Isn't that true?
I was not made aware of that, no.
This is irrelevant to today's cases. Any prior legal issues do not have any evidentiary value on today's case.
Your Honor, this is not a prior legal issue. I'm just exploring what the state of this coaster was when Avery Mansion wrote it, which is highly relevant to today's case. If there were any issues with the padding, which is a key safety feature on this coaster, I'm not asking whether she had any prior lawsuits or anything of that nature, only what Avery Mansion would have experienced when she rode that coaster.
All right, I'll overrule the objection. You can explore whether she was aware of any possible safety issues with any parts of the ride. Go ahead.
You just told this jury that the padding meant to protect the riders with that harness was frayed. Isn't that what you just said?
No, the padding was not frayed. There was some fraying on the outside of the harness, like the material outside, but the padding was fine.
The padding was not fraying?
The padding was not fraying, no. The U-harness, like itself, the material was fraying, yes.
Thank you. No further questions, Your Honor.
Any read?
No, Your Honor.
Read yours. Okay. All right, you can step down. All right, call your next witness.
This time the defense calls Rowan Clamp.
Okay.
Could you please introduce yourself to the members of the jury?
Hi, my name is Rowan Clamp.
Ms. Clamp, are you currently employed?
I am. I work at Captain Kidd's Pier. I'm the mechanic shop manager there.
What are your responsibilities as the mechanic shop manager at Captain Kidd's Pier?
Well, my primary responsibility is servicing all the rides at the park. We currently have 8 rides, and it's my job to keep them all up and running.
Thank you. No further questions.
Cross-examination.
Ms. Clamp, August 19th, 2017, the day that Miss Mansion rode the Hurricane roller coaster, you were working that day, right?
Yes, I was working that day.
You were the ride operator of the Hurricane roller coaster, is that right?
Yes, the Hurricane is our most popular ride.
But Ms. Clamp, you're not the regular ride operator of the Hurricane roller coaster, are you?
Regularly, I do not operate the Hurricane, no.
Everything else in the park was still going on, just not the rides.
Yeah, we still have the games open.
Thank you, Ms. Clamp. No further questions.
All right, the witness can step down.
Defense calls Dr. C.N. Boats to the stand. Good morning. Could you please state your name and occupation for the members of the jury?
Good morning. My name is Seymour Bones. I'm an orthopedic surgeon. I specialize in injuries located on the spine and spinal cord.
Doctor, where are you currently practicing medicine?
I'm the medical director and chief of the orthopedic department at St. Mary's Medical Center. I'm also a full attending surgeon at Metropolitan University Hospital.
Now, at this point, I'm going to ask you some questions about your medical opinions. Do you understand that all opinions must be expressed within a reasonable degree of medical probability?
Yes, I understand that, and I will limit my answers to that standard.
Thank you. No further questions, Your Honors.
Cross-examination.
Dr. Bones, you spoke with Miss Mansion this past July, right?
Yes, I did.
That was 11 months after her incident, right?
About so, yes.
And when you met with Miss Mansion, she complained to you of numbness in the hands, right?
That was one of her complaints, yes.
Weakness, right?
Yes.
Loss of strength.
As I said before, yes.
She told you that she can't even really handle a toothbrush anymore, right?
No, she reported difficulty holding a toothbrush. She never said she couldn't hold a toothbrush.
So she had difficulty using a toothbrush, Dr. Bones, right?
Yes.
And when you met with her, her pain seemed to emanate from the neck and shoulder area.
At a different level than the bulging disc is located, yes.
Thank you, Dr. Bones. No further questions, Your Honor.
Yes, Your Honor. So, do physical tests taken, show the actual disc condition?
No, they do not.
No further questions, Your Honors.
Any recross?
Nothing further, Your Honor.
All right, the witness can step down. Defense rests at this point.
Take a 5-minute break right now. We're going to remain in the courtroom. Go ahead, prepare for your closing statements.
Right, under the rules of court, the defense proceeds first with the closing statement. Is the defense ready?
Yes, Your Honor.
Okay, please proceed.
We agree. The plaintiff does have injuries. What we don't agree with is the cause of those injuries and the extent of those injuries. Today, it was the plaintiff's burden to prove that negligence by Captain Kidd's Pier was the proximate cause of the plaintiff's injuries. Today, they have failed to meet that burden because actions speak louder than words. Let's start with their claims of negligence. The plaintiff told you how she didn't know to fasten her seatbelt, because Captain Kidd's peer never told her to fasten her seatbelt. But what do the plaintiff's actions tell us about that? Well, before getting on the Hurricane roller coaster, Avery Mansion watched the previous passengers get off the ride. Now, to get off the ride, what must those passengers have done? Unbuckle their seatbelt. And for someone who claims she's just suffered a traumatic, life-changing injury, well, the plaintiff's actions don't support her allegations. And actions speak louder than words. Find Captain Kidd's peer and Lynn Pingree not liable. Let your words reflect the plaintiff's actions. Thank you.
Thank you. Plaintiff?
What do you expect, members of the jury, when you visit an amusement park? You expect to go on safe rides. You expect that the park is in fit condition, that it's not in disrepair. You expect that the ride operator of the roller coaster that you're on is paying attention. They can see that they're there to help you and that they're going to make sure that you're safe on the roller coaster. You expect to enjoy yourself on the roller coaster and then get off and carry on with your day and carry on with your life as it always was. Unfortunately, members of the jury, we learned today that you don't get any of that when you go to Captain Kidd's Pier amusement park. Instead, what you get is an accident waiting to happen. So, members of the jury, because it was the Hurricane roller coaster that was in a condition of disrepair, because Captain Kidd's Pier's negligently inadequate safety procedures proximately caused Miss Mansion's injuries, because those injuries are permanent and severe, because the accident waiting to happen at Captain Kidd's Pier finally happened, we ask that you hold this amusement park responsible for what it did to Miss Mansion and find it liable for the injuries that she suffered. Thank you.
Thank you, Mr. Fisher. Thank you to both counsel. Members of the jury, you are the judges of the facts. You have the obligation to, after lunch, after enjoying your lunch, step back and assess the evidence. Your task is set forth on the verdict sheet as you determine the question of negligence in this case, and I understand you're familiar with the jury charge as well. We're not going to read that for you now. You'll have it back with you. Enjoy your lunch. Let us know when you have reached a verdict. We will take 30 minutes. Please be seated, everyone. What say you, our jurors? Have you reached a verdict?
We have, Your Honors. We find the defendant, Captain Kidd's Pier, to be negligent, to which their negligence was a proximate cause of the accident. Furthermore, we do not find the plaintiff to have been negligent. And we find the damages owed to her to be equal to the total amount of her scholarship in addition to her medical bills.
Thank you, members of the jury. You are discharged with our gratitude. We saw two spectacular performances, truly, and we're not just saying that, which makes it hard to select one that comes off slightly higher in the scoring than the other. We found for plaintiff, and we offer our congratulations to both teams.